I think we should get started and then we'll let everyone else turn up. Chris and Josh, thank you so much for coming and talking with me today about what to do if you're unhappy about the care that you or your loved one has received. We've got a few little housekeeping rules before we get started, and then I'll let you introduce yourselves. So if we can move on to the next slide, Holly. Brilliant. So we are going to record the webinar because we find that lots of people like to come back and watch it again. And we know already that we've people waiting to see it that couldn't attend today. So you've seen Maya, our head of comms, is saying hello to you all in our chat box. So please do use that to introduce yourself and to each other, because it's good for us while we're having this conversation to have a feel of who's in the room. The closed caption function has been enabled, and we ask that you, just as a reminder, there's also a question and answer box. So if you can put your questions to the panel in there, because it's much easier for us among kind of chatter in the chat box to keep an eye and make sure that we can address all the questions that we get. And then please don't take photos or screenshots of the speakers. And obviously, I think you understand that neither Chris or Josh are able to provide legal advice on individual cases as part of this webinar, but are here more to give you a general overview of the complaints process and to, hopefully give you the knowledge and skills that you may need to raise issues that you've had or are having on behalf of yourself or our patients. So I'm delighted to very quickly introduce myself. I'm Rachel. I'm the Chief Executive of the Patients Association. And for those of you who joined us who don't know, we are a national organisation which are unique in the sense that we have patients as our members. And our purpose in being is patient partnership in design and delivery of services, because we genuinely believe that if services are designed with patients and for patients, that the services will have better outcomes for patients, better for staff, but they'll be high quality, but also they'll be safer services, because we really need to work in partnership in the design of those services, but then individually in shared decision making. And I know we'll kind of touch on that today, guys, as well, because that piece about patients and healthcare professionals working together stops us from getting to the stage where sometimes we feel that we have to complain. And the reason behind, so we have a national free phone helpline that operates Monday to Friday. And the phone number for the helpline will be on one of the slides at the end. But we get a huge amount of calls to our helpline around. So it's one of the key calls that we get is what to do when somebody's unhappy about the treatment that they've had, and that varies across, not being able to get an appointment, getting delays in obtaining surgery or hospital appointments, or in a lot of cases second opinions. Sometimes a lot of it's around the conduct around the administration and what's happening with information and communication about what's happening next. So we know that we've a long, pretty long waiting list for elective surgery right now. And patients say to us sometimes they just don't know where they're at. They don't know what the next stage is going to be, and they can't find out the information that they need. Obviously, sometimes there is complaints around the conduct of healthcare professionals where, again, and I speak about this so often, where patients feel they're not being listened to, Josh, and I'm sure both you and Chris have a feel for hearing this from patients as well. And we've gone back to, you go back to the mid-staffs inquiry and you come forward to every inquiry since then. And one of the key issues coming up time and time again is patients not getting listened to, and that culture that sometimes can be quite defensive in that area. A lot of complaints come in around access to referrals, but also accessing your medical records is a big issue. And for our downloads as well, on our information and guidance section on our website, accessing your medical records and what to do if sometimes your medical records aren't completely right, has an issue with the calls coming through to our helpline. And then we do get, some really sad stories about poor care in a hospital setting and poor care in a care home setting. And as part of that, we're a member of the CQC Tell Us Your Care scheme that, hopefully gives CQC more information about what to do, either with some of the information that we give them. It often can trigger a CQC appointment, or it can be used for one that's coming up as evidence or information that they've received. So, we do what we can to make sure that we can bring the information that we hear through the kind of complaints work that we do to try and affect change. And I know that's something we'll probably talk about a little bit in a few minutes as well. So before we get going, can I get you to introduce yourselves? So Josh, I'll let you go first.
Thanks so much, Rachel. Yeah, my name's Josh. I'm a partner at BBK. Over the last decade or so, I've specialised in bringing claims for those with personal injuries, and that encompasses those harmed by medical negligence. And I think as a firm, we've been working with the PA for a little while now and supporting the valuable work that they do, as Rachel's just outlined. Because whilst our primary role is to help people recover compensation where they have been harmed, we do recognise that most people who've had poor experiences with the NHS don't necessarily have those claims, and they require support in much the same way.
Yeah, thanks, Josh. And Chris, who we're going to see on a video at the end of this webinar.
Yes, lucky everyone. So I'm Chris. I'm a solicitor in the medical negligence department. I work with Josh. I've worked with the PA for the last year or so. And as Josh says, a lot of our clients, the people that come to us investigating or asking about the potential of investigating a claim, will often be dealing with the initial situation of making a complaint, whether anything immediate can take place, whether steps can be taken in the sort of shorter term as well. So there is some overlap certainly between the complaints process and the claim process that we help with.
Brilliant, thanks, Chris and Josh. And in my previous role, I worked in hospice care, and I used to do a lot of work with our staff about understanding why people may complain. And I think for me, if you're in a situation where you're not getting the best care that you think you deserve, or your loved ones, you're feeling very, very vulnerable. And so it must be really difficult, because most times people just want it to get better. Just don't want this to be happening to your loved one at the time when everything feels so anxious. So, we have the NHS Constitution, Josh, and what does the NHS Constitution say about how complaints should be managed, or what does it say in reference to complaints?
Yeah, it's quite helpful actually. It's basically a charter, and some describe it as kind of the NHS's moral compass, if you like. It sets out the rights and responsibilities of healthcare professionals, but most importantly, patients. And there's obviously a big emphasis on improving patient safety and learning from past mistakes. And that's, I suppose, where complaints come in, and the importance of complaints comes in. It's our right as NHS patients to complain, and indeed that's enshrined in the Constitution. And if you go into that document, it is accessible online, and there's an easy to read version of it as well. It does set out some helpful information. So, for example, you have the right to have your complaint acknowledged within 3 working days and to have it properly investigated. You have the right to understand how long it will run for, and of course to have the conclusions explained to you once they're available. You also have the right, if you're unsatisfied with how the complaint has been managed by the particular trust or surgery, to have it escalated to the next stage, which is the Independent Parliamentary and Health Service Ombudsman, which we may mention again in due course. And then, of course, where we come in is where there may be harm suffered as a result of negligence, and you have the right enshrined by the Constitution to claim compensation. And the one final point I would make on the Constitution, Rachel, is that we often hear that people are quite nervous about the idea of making a complaint, and certainly bringing a claim. as a country, we have a really close connection with the NHS, and I don't disregard that for a moment. It's a real human, understandable emotion to be reluctant to do those things. But it's through complaints and medical negligence claims, rightly or wrongly, that we hold people to account. And from experience, things don't tend to improve at quite the same pace without those complaints being made.
And I think
Yeah.
actually, if I may, Rachel,
Yeah.
I think it is so important, particularly at these times when people feel vulnerable, that they realise it can be a very intimidating situation to raise a complaint with a healthcare provider, a doctor. I mean, the saying, a doctor's always right, a doctor knows. It's almost drilled into us from a young age that it can be quite difficult to question it. Am I is this in my head, or is something really going wrong? If you do feel that there is an issue and you'd like to raise it, it is enshrined in rules, in law, and it is openly acknowledged that the NHS and care providers do want to hear that. So hopefully it should provide a little bit of confidence in those situations, because it can be difficult.
Yeah, it can. And I really feel for some of the stories that I've heard from people who tried to make complaints. And I think, Josh, you talked there about the conclusions being, you're right to have an investigation and you're right to have conclusions explained. And we've done pieces of work with different NHS trusts around the complaints process and our own toolkit. And often what we find in there is when they go to have the conclusions explained, you might have put in like 6 different areas to your complaint, and the conclusion letter will come out and it'll only address 2 of them. And patients say, well, why won't they just, and actually what it is about having that genuine dialogue and that genuine partnership. So, we've been seeing a lot about the NHS not listening to patients, and we do all know that in areas there's really good practice, but in certain areas there's a culture of defensiveness, and there's that psychological safety for staff to be able to say, I actually got it wrong here, because in a lot of cases that's what patients want to know. They want to know how they can get their second opinion. And I'm quite mindful that I have spent the last few weeks attending a couple of meetings about Martha's Rule, and that is the young girl who died of sepsis, whose family, whose parents, who have met on numerous occasions now over the last few weeks, and amazing people that push this forward, who have said they just weren't listening and they just would not go and get more help. So that's the extreme of this young girl lost her life, and she shouldn't have done. Where if the kind of calls for concern or the calls for review, or them being able to call somebody else to come in pretty quickly to have a look at that, we have a duty of candor, Chris, that gets gets thrown around the place quite often. It's a good duty, but tell me a little bit more about that, and what's relevance it is to making a complaint.
So the duty of candor is also enshrined in rules, in law. All healthcare professionals have to abide by this requirement for duty of candor. What that means is they have to be open and honest with their service users. It's particularly important when things go wrong, and so there are specific recommendations and requirements for how people are supposed to handle what to do, and how to handle a situation when things have gone wrong. And the point is, I suppose, it shouldn't necessarily be for the patient to raise a concern. If something has gone wrong, this duty expects that the patient or their family are told. So they specifically require doctors and healthcare professionals to provide to flag that there is an issue, provide information about what's happened, provide an apology if that's appropriate, and offer a remedy or support to put things right. And I know, I'm sure a lot of people, and often rightly, could be quite skeptical about this. You know, it's all well and good that this is encouraged in the rule. You know, does it happen in process? Well, I think from my personal experience, probably it's fair to say that it sometimes is in play and sometimes isn't. But I think it's fair to acknowledge when things do go right. And I have seen personal experiences and examples when people have come to us and a major error in their care has occurred, and that has been flagged to them by a doctor, which otherwise they wouldn't have been aware of.
No, and that's, you know, we know that that really good practice happens as well, but we're seeing in the chat and other areas, and rightly in the chat, I was reminded of Oliver's campaign and Paula and the amazing work that she did in getting all that work recognised at the senior level at NHS about how Oliver's care was so badly wrong as well. So I just want to acknowledge Oliver and Paula while we talk.
I mean, it would represent an enormous change for the NHS. I think you mentioned, Rachel, before about mid-staffs, and I mean that's how it came about, and that huge cultural shift that we need, and is, you know, absolutely nowhere near complete and in progress. But that whole paternalistic doctor knows best culture is still with us for sure, but hopefully we're chipping away at it.
You know, if I think away from the complaints, when we talk about patient partnership and patient power, we talk about healthcare professionals having the confidence to hand that patient the power, that they are the people who know their body, they're the people who know what's most important to them in their lives and what matters to them. So, but there is something here that, you know, you talk about duty of candor, and Chris, you mentioning there, you know, that it did come back from mid-staff, and you mentioning doctors or healthcare professionals saying this has gone wrong. So there is definitely the cultural issue there that, you know, us on this call today aren't going to be able to do anything. Somebody has decided to start building next door to me. Apologies for any noise you can hear. So if we can't change the cultural issue, but in terms of how the complaints process, Josh and Chris, how, you know, could you give us an overview of the different stages and maybe break it down for people on the call?
Well, I'm happy to start with that, and obviously it is a large topic, but I think it's probably sensible to start with who to make a complaint to and the different forms of complaint, because that will inform the best avenue for you. There is no one best approach or avenue to a complaint. It will depend on the situation, on the relationship that you have with the healthcare professionals and you yourself, and what you're comfortable with. And I think probably an important initial distinction is when you have a complaint or a concern that you want to raise about ongoing care. So care is, time is often of the essence, and you would like to change how you're currently being treated. That is certainly different to a situation, how best to handle it, if you are looking back on something that has occurred and you have the luxury, I suppose, of being able to write a complaint and set out your concerns. In terms of dealing with the former situation, when time is more of the essence and you want to affect immediate change with your care, there probably are a number of options to go through. Initially, speaking with the clinicians that are treating you, try to get some clarity about what's happened, why something has happened, what the plan is going forward. I expect that people who are listening to this will find that first avenue, often hasn't been helpful, and so you might need to escalate it. A second option is to speak to the patient advice liaison service, PALS, that every hospital has. People have mixed experience of that for sure, but PALS, for people that aren't aware, are a body that sit within most hospitals, and they should essentially act as a go-between between the patient and the clinician. And they do tend to be better when time is of the essence and they need to push some treatment through. If something isn't happening, then PALS is certainly a good place to start.
Brilliant, Chris. So I am going to, before we go on to the next stage in the complaints process, we hear a very mixed bag of information regarding to PALS. And I think there is a few questions coming in, and in general, they're saying, I tried to use PALS. Should PALS be more independent of the hospital? There doesn't seem to be a coordination of PALS. So you're either going to get a really good experience with PALS, or from what we've heard through our helpline, a really bad experience of PALS, where it turns into, and this was actually a healthcare professional who described it as the Doctors' Defence Union. So how would you, or do you have advice about how to interact with PALS?
I mean, my experience is much the same as what you've been getting, Rachel. We see both sides of it. I've definitely seen scenarios where the response has been, probably could be described as a whitewash, where it's been dealt with poorly, and it's kind of a block on. It's quite clearly like almost a defence union approach. And I wouldn't be, my advice, I suppose, is I wouldn't be too perturbed by that. That's not determinative of whether there's, from our perspective as lawyers, that doesn't mean that there's no claim there in the circumstances of a medical negligence claim. I've got an ongoing claim at the moment whereby an 18-month-old chap was delayed diagnosed with congenital glaucoma. And he suffered a delay in diagnosis of many, many months, long beyond the period when he should have been diagnosed, and suffered visual loss. And the parents rightly went through the complaints process and came up against a brick wall initially. But they kept pushing. And as you say, not accepting that only 2 of 5 of the allegations or complaints were dealt with. They kept pushing for the residual to be dealt with, and it did ultimately result in a serious investigation report. And again, that was a stonewall. No, we don't think there was any failings here. And then it came to us, and we instructed a pediatric ophthalmologist, and indeed his view was actually glaucoma was there to be diagnosed much sooner. A complete contrast to what PALS in the serious investigation report had outlined. And ultimately, there's been admissions of liability, because you're then talking to a different group of people. So I suppose the overarching point being, Rachel, I wouldn't be perturbed. It's not determinative of the next step if PALS do stonewall. But as the Constitution says, you've got every right to have all of your complaints dealt with.
Yeah, and
Go on, sorry, Chris.
No, go ahead, Rachel. Sorry.
No, please go ahead.
I can certainly echo what Josh says, in that it perhaps can be seen as more of a starting point, and this applies to all aspects of the complaint. As Josh says, if you receive a response that you think doesn't really make sense, or doesn't answer the questions, then it shouldn't necessarily be the end of the road, and it doesn't mean that you're wrong. because we've both, I mean, we have certainly both seen plenty of situations where a response to a complaint or investigation has been completely at odds with the independent evidence that we subsequently receive. So although we are talking a lot about the complaints process, and there are lots of positive examples, we're not necessarily, I'm not sitting here trying to say the complaints process is absolutely the answer all of the time. It is sometimes, but also equally, don't be too put off if you don't get what you want from it.
So I suppose my other concern about the complaints process, especially at this early stage, is that piece of that thing about power as well. So if you come from a background at risk of inequalities, or you have English as a second language, or we've got a health literacy age that I think is between 9 and 12. You know, how would you advise people on this webinar to stick with it? How can they get other support before it becomes to a situation? Because we are going to go and talk about solicitors and lawyers becoming involved in cases, and at what point that is appropriate. But you know, how would you encourage patients who have something really valid that they want people to learn from? What are your rights? Do you have rights to have an advocacy person come with you? Can you request to do it in easy read versions of letters, or do you know?
Yeah, I'm certainly aware that there's via the NHS, I think it's called Voiceability, where you can obtain support in terms of advocating your complaint. And again, as part of the Constitution, you have the right to seek additional support from those handling your complaint. Not everyone's the same, and whether it's reading or language, that absolutely should not be a bar to you being heard and being listened to. The other thing is that if you've got a support network around you, friends, family perhaps, that you think may be better placed to assist you, then whilst you might find that the NHS or PALS will seek maybe some written confirmation from you as the affected person that you're content for them to liaise with your friend or family member, again, that should be a decent way for you to proceed as well.
Brilliant. So we've kind of covered the first step of the complaints process. Chris, is there more you want to talk through in the complaints process?
I suppose it might be helpful to mention, and perhaps we're sort of coming onto this, but what to do if you receive a response from PALS that you're not happy with, or you want to take a complaint to a more formal level, because there is a whole sort of network that should be there to enable you to do that. So if you are unhappy with the response you've received from PALS, or you are looking back sort of slightly after the fact, and you are comfortable with writing to the hospital or the GP, whatever healthcare provider it is, that is always an option to provide a written complaint to whichever body it is that you're unhappy with. So to take a hospital, for example, so hospitals are run by trusts. Most trusts will have a complaints department to deal with complaints specifically. If they don't, then you are able to send a letter or an email to the chief exec. That's typically how they are dealt with. If the issue is with a GP or a secondary care provider, then in the first instance, organizations will recommend that you raise a complaint with the healthcare provider themselves. GP typically will be the practice manager. If you receive a response that you're not happy with, or you're not comfortable with that, then you will have to, it will be worth finding out who the integrated care board, ICB, it's called. They will tell you who it is that provides the care, funds the care for that healthcare provider. And so that will cover things like 111, out of hours, mental health services, and then each provider, each funder of those services will typically have their own complaints process. And my recommendation, if you would like to take it down that route, would be to provide a complaint in writing if you're able to, or seek advice and help from organised charities or NHS advocates to help you do that. And I'm sure we can talk about, advice on how best to do that.
Yeah, just to add as well, because I think we're seeing this more and more, certainly in our work, is the increased use of private providers of healthcare. And in those circumstances, you're best going straight to the manager of said clinic or hospital that you received that private care at.
Yes.
So on mute, Rachel.
Sorry, I decided the noise was getting quite heavy outside. So a lot of independent sector hospitals are registered with somebody called ISCAS. Yeah.
Yep,
So when
right.
we get calls, we recommend that if somebody is choosing an independent sector provider, that they should check first that they're registered with ISCAS, which I cannot think what ISCAS stands for right now.
Independent Sector Complaints Adjudication Service.
Brilliant.
Bit of a mouthful.
It's just a bit of a mouthful, but I think that it's a really good point for anyone going to the independent sector to make sure that they are registered there, so that there is an external complaint process for that trust, that it goes through that. Is that right? Yeah.
Yes. So most private healthcare providers are overseen by ICAS. And so if something goes wrong, they recommend local resolution, i.e. complaining to the manager in the first place. And then if you're not happy with that, then you can raise it with them, and they will oversee, as I understand it, they will oversee an internal review, a local review, and then they'll also provide facilities. If you're not happy with the results of that, you can ask that an external review is made. If you do find yourself in a situation where a private healthcare provider isn't affiliated or overseen by ICAS, then usually I believe it's the Care Quality Commission, CQC, who oversees private healthcare providers. So even if you're not happy with what you've received from ICAS, or if they're not, then you can talk to the CQC about.
But CQC won't look at individual cases, but it'll look at the theme around the cases, won't it? So I think that's why ISCAS is a good thing for people to make sure that, because it's signed up to a higher quality of complaints process. Brilliant. So if it was me and I had, like, how do I focus my complaint? Because I think sometimes when something has gone wrong, there's quite a lot that's gone wrong. And if you put a letter in with all of that in there, is that too much? How do you delve into what's the most important thing?
Yeah, I think that's a really good point, Rachel. I think it's very, very easy for people who are going through this, or have just gone through this, or their loved one has gone through something really traumatic, to get it all down in chapter and verse. And honestly, from my perspective, I think it can sometimes detract more than it can support the power and utility of a complaint. So I think if you can try as best you can to kind of narrow the biggest, strongest points at the start, and be as concise as possible. I know it's really tempting to put down every point that you encountered during this relevant period of time about X said this and Y said this, and I thought she was rude to me. I understand all of that. Those things shouldn't happen. But from a complaint perspective, I don't necessarily think that is entirely conducive to putting a powerful statement of facts together when making a complaint. Chris, would you agree?
Absolutely, absolutely. My advice would be to try to focus on the things that are most important to you, and the issues that you most want to see resolved, the questions that you most want to see answers to. Because if you were to sit down and write a list of all of the issues that have happened, of all of the questions that you'd like answers to, although you probably are well entitled to that, it may just undermine what you're going to get back, and there's a risk that people will perhaps, as you say, only focus on 2 of the 5 things and possibly not focus on the most important aspects that you want covered.
So there's a theme coming out in the questions as well, which talks about, you know, we have whistleblowing legislation for staff. How, you know, should patients be protected or have protection in terms of when they're making a complaint? Because there is a fear, and I know when I used to do complaints training, there would be a fear. I used to explain that, you know, if a patient or their loved one's making a complaint, it's a really brave thing to do because they want things to be better. But they can be very scared, and we do hear this in our helpline, they can be very scared that there's going to be retribution, that their loved one mightn't get cared for as well, or that the care might even get worse, or that they get seen as troublemakers.
Yeah, I hear that a lot as well. I must say from my experience, whilst a completely understandable feeling and fear, I almost exclusively see the opposite effect, Rachel, in that if they see a letter from us at the one end of the spectrum or a complaint from the patient at the other end of the spectrum, they almost see a Rolls-Royce service, or certainly an improved service. And I think that's probably emphasised if there's a meritorious claim that they're somewhat aware of and concerned about. I actually think in practice we probably overthink that aspect a little. Easy for me to say, whilst I accept.
No, it is easy for us to say that, but I think it's a real genuine thing because, you know, we're at that vulnerable position. But probably then that's why I, you know, again, when I did training about complaints, was saying, you know, let's welcome complaints with open arms, show the fact that we're a learning organisation, that we know we're going to get it wrong, but we can turn that around and we can get it right, and that we can learn, and that's a lot. So before we go, so there's some point the patients end up at your front door. At kind of what point do they end up at your front door?
Chris, do you want to? I'm happy to answer this.
Yeah, please do.
At all different points, really. There's no hard rules. No hard and fast rules on that at all. As I said before, you're not obliged to complain at all before seeking legal advice. There's no obligation on you to do that. I would say it often assists us if there has been a complaint process that's been followed, because it helps set the scene. I think it helps create a bit of certainty on dates and identities of when things happened and who by, and just generally provides us with a bit of a chronology, and maybe even to see what the trust or the GP position is likely to be in response to what will be allegations. I suppose what I would say is that you of course have to bear in mind this, what we call limitation, which is the general rule being you have 3 years from the date of the alleged negligence, or from the date at which point you became aware that there could have been negligence that's harmed you, to commence court proceedings. So that is quite a strictly enforced rule of the courts. So I would suggest as a general point, if there is time to go through the complaint process before seeking legal advice, then do so. It can be helpful, but certainly keep a very close eye at that 3-year time limit, because if you are creeping closer to that, and that could be, you know, a year has gone by, 2 years has gone by, that can act or become more of a barrier to seeking redress in a legal sense.
Thank you. And the $1 million question is, you hear a lot about how expensive solicitors are to come to. So, you know, if somebody wants to come, what is the process before they kind of get to a point where, you know, how much are they going to have to pay? People who just can't afford it and have a genuine complaint.
Yeah, sure. I mean, it's a big question, and people can sometimes be hesitant on bringing actions because of this very point. So I think if a solicitor is feeling awkward or is not clear with you about how the cost position will work, then it's not a good sign. So there's a few funding arrangements available. A couple of them are less pertinent nowadays than they once were. I'll quickly tackle those. One is legal aid, because that's probably one of the few terms that people recognize in the context of civil law and legal costs. But in reality, that's kind of been eroded. So public funding, i.e. legal aid, is not really available unless you've got perhaps a baby who sustained serious brain injury at birth. Apart from that, it's not really available, sadly, to harmed patients. Secondly, privately paying. Diminishingly rare, to be honest, that you would fund your own medical negligence case. They're exceptionally expensive to run. You'd have inevitably medical experts involved that will need to be paid to support your claim. And there's just a lot of risk that is involved in funding a claim on your own. So not something I would be keen to encourage anyone doing. And the reason for that is because of the third option and the overwhelmingly dominant method by way you fund your cases by way of conditional fee agreements or CFAs. I suspect you haven't heard of CFAs, but you will have heard of no win, no fee agreements. They are the same thing. They are conditional in terms of costs only become payable if the claim succeeds, i.e. if you instruct the solicitor and no compensation is recovered, then there are no legal costs to be paid by anyone. They are simply written off. And frankly, whether you have a multi-million-pound cerebral palsy claim or whether you hear about those whiplash claims that recover in 3 weeks, a CFA or a no fee agreement is the method of choice. And that is because it's a very, very, very good way of an individual accessing legal representation without having to pay upfront fees. Yeah.
That's interesting. I didn't. So, but you know, you do hear, well, maybe I just hear some bad kind of, or maybe I have placed, and I know it's hard for you, you can't answer this, but I've placed bad feeling towards kind of the no win, no fee, and you turn on, you know, you ever turn on TV and it's like, have you done this? You can win fortune. And that just gets my anyone who advertises on TV like that worries me. I don't get to watch too much daytime TV, but when I do, that's what I shout at.
No,
So,
I mean, the industry has a lot to answer for in that regard, Rachel. I you know, the whole ambulance chaser thing is an issue that we're very
yeah,
live
so
to.
so somebody, I turn up to you tomorrow with a serious complaint, or claim, or whatever language we start to call it when it ends up with you. You then decide if it's a worthwhile complaint. I'm assuming that there's points where you say this isn't going to go anywhere or it is going to go somewhere.
Yeah, absolutely. There's a fairly robust risk assessment that Chris and I and the team have to abide by, because I mean, ultimately litigation is stressful, it's time consuming, it is absolutely not to be entered into lightly, as much as we try and take the stress away from harmed people and claimants. There is inevitably a distinct level of stress, and so we have to be pretty sure. Obviously, we fight difficult cases all the time, but at the outset, we're not here to tell people what they want to hear. We're here to tell them what the law is and whether we think there is a better chance than not that they will ultimately recover compensation at the end of the process. And I think, whilst perhaps an unpopular opinion, we do a very important job. Certainly, reputable lawyers do a very important job of ensuring that the NHS are only defending claims that have merit. You know, I don't think, as much as the media like to play it up, there's not many solicitors that will run cases for the sake of it, because they will soon go bust. There's no commercial sense in running unmeritorious claims, and it's not fair to people
No,
who
it's
are
their
in the
lives you're
background.
messing
Quite.
with, isn't it?
Yeah.
So then you decide to take the case. We'll move away from this and back to the complaints process, but just want to be clear for people on the call, because I can see some of the questions around here. You decide to take the case because there is legal merit in it. It's, you know, the risk assessment has said there's a reason why we need to take this forward. There is still no charges to the person who's taking that through till it gets finalised. At which stage, if there is an award or remedy, maybe it's better language for it, because it's not an award if you've been damaged by negligence, that you then would only pay, and you'd know what those kind of fees might look like at the point.
Absolutely. Yeah. So at the very outset, you will agree with your solicitor what deduction there will be in the event that you do succeed. So we've talked about what happens if you do not succeed, i.e. you don't pay anything at all. In the event that you do succeed, there will be no point in time where during the lifetime of the case your lawyers should be coming to you and asking you to fund anything. That's part of the deal, if you like. We fund disbursements, or what we call expenses of the claim, so paying medical experts to advise or paying the court fees. That all is part of what we will fund. But ultimately, if we are successful, there will have been a percentage deduction agreed at the outset. So you know with certainty that if you provide us with reasonable instructions and you abide by reasonable advice that we give, at the end of the case, you know you'll walk away with a percentage of your damages, and it can't waver. So yeah, there is certainty at the outset, and you don't pay anything. You only pay, for a percentage of your damages recovered, so nothing funded in the interim.
So ideally, the idea for these arrangements is that there is nothing to pay up front, and there shouldn't be a point at which you're out of pocket. It will only be deducted from compensation that is achieved. It's designed to provide a fair bit of protection if done properly. You're on mute, by the way, Rachel.
That is because they've decided to rebuild the whole street outside the window. Saying it's usually quite quiet. So in terms of very quickly summing up some of the stuff here that you've been saying, you don't have to go through PALs. You can start a complaints process without talking to PALs.
Correct.
You don't have to complete a full complaints process before seeking legal advice or going down the legal route.
Correct.
But it's helpful to have tried to do that. It's helpful because you then will have documented where you got to with what went wrong.
Sorry.
Go on.
I would say that the two processes are entirely separate. So making a complaint and a claim, they are two very separate things. And there, as Josh said, there is limited overlap in the sense that a complaint can be helpful for a solicitor, but it's certainly not essential. And I don't think I would ever say to someone who came to me who hadn't made a complaint, "Oh, put a complaint in before I, look at a claim." I think the decision to make a complaint should generally be taken on its own merits, really. If we can make use of it, then obviously we will. But if you would prefer to have absolutely nothing to do with the healthcare provider, which is often the case and totally understandable, you're more than able to talk to a solicitor, and they will be able to take on the case if they think that they can.
Brilliant. And then there is a few questions about this in the chat as well. Can people kind of pick and choose in a sense? So we have lots of information on our websites, as have some people just posted from Health Watch, the national agency as well, and the local health watches, information about how to make a complaint. We have some draft letters. But if somebody wants to do kind of a pick and choose kind of thing and come and get legal advice to say, look, I want to do the complaint, I want to do it myself, but actually just want some help with pulling together letters, is that a service that you can offer or anyone else can offer? Or is that just a really difficult question?
No, not really. I think it's a difficult answer in that we as medical negligence solicitors can only act where someone has been harmed as a result of negligence. So there is quite a high bar for that. But I certainly think there's probably other people that are better placed to do that. So it's just a separate role, if you like, Rachel. It's not a case of kind of willing or desire, I guess. It's more just because we focus on the part of the journey which involves, that high bar of breach of duty and causation being satisfied.
Yeah, no, that's fair enough. And I think for those people that are asking that question, we can have a look at some of the resources we have on our website around how to make a complaint and see what else we can put on there that might be of help. So my team are in the background going, she's just creating a job for me. Brilliant. So I'm just looking, sorry, I'm looking at all the questions and just trying to, I think we were I'm just trying to pick up on the rest of the questions. There's something about, sorry, were you going to say something, Josh?
No, I was just going to say, I can see one talking about if there's a lawyer involved, will the complaints process run? I'm certainly aware where the Ombudsman has been engaged. If there's legal representation involved at that point, they will not progress with it, because I think they'll see it as a duplication of efforts, if you will. Muted.
Sorry, not to. So, if you're with the Ombudsman, you can't be taking legal. There can't be a legal claim going through at the same time, because that's kind of a duplication of a process.
Yeah, the legal process will take precedence over the Ombudsman process.
So the Ombudsman will hold on it. Somebody's in the that's good for people to know, because I know we've had that issue come through our helpline, that the Ombudsman will put it on hold if there's a legal process going through at the same time. 3 years, that's the time limit for a complaint?
Well, no, actually 3 years is the time limit for making a claim in negligence. The time limits for complaints are different. Obviously different providers can to a point probably set their own time limits. Okay. As I understand it, generally the NHS sets a limit of 12 months within the incident, but I am aware of occasions where they will deal with complaints outside of those timescales. I think if someone has missed that deadline, it would probably be worth explaining why they have left it more than 12 months, particularly if there is good reasons, to do with health or whatever it is, managing the injury that has come about or the subject of the complaint. But it is generally shorter.
Quite often, something might be more than 12 months before it becomes apparent that it's gone wrong in terms of medical treatment.
Yeah,
I think at that point you could probably very reasonably say, well, I will have 12 months from that point in time. So the point at which you have cause for a complaint, I suppose.
And then obviously Bolt Burdon Kemp, you come here, you've given us free advice, which is fantastic. How do people find a good solicitor in different parts of the country? So somebody is asking a question around, maybe solicitors who can deal with social services issues and not so who can deal with the whole health and care arena. But like, you know, I know there's the top 5, there's top 10, but is there like a registry that we can go on and go, yeah, Bolt Burdon are number 1?
Yeah, there's a couple actually. I think it's really important, particularly from a medical negligence perspective, that you engage solicitors who have a track record in this area, because it's not to be dabbled in. And I think the cases that we can sometimes take over from other firms, oftentimes are where they have perhaps sought to dabble in this area of law, and I just, you know, it can't be done. It's too complex, and perhaps I would say that. But in terms of registries, we have what we call legal directories. There's what we call chambers and partners. There's a Legal 500, the Law Society. From a personal injury perspective, there's something called APIL, which is the Association of Personal Injury Lawyers. All of those resources, you can find lawyers that are accredited in a particular area that you need. But from a ranking perspective, I think Legal 500, Chambers and Partners is where you can get some kind of peer reviews from people in the know, really, I suppose.
Brilliant. I think we'll put that link to APOL that Olivia's kindly put in the chat box onto our website and chambers.com as well, so that people in time can get there. So I'm really sorry we're running out of time. I think it's been really helpful discussion. I think we've addressed a load of the questions that have come in. We're just now going to let you see a video that Chris talks more, and this video is downloadable, and we can put a copy of it in the chat as well, where Chris talks more about so first of all, do sign up as a member of the Patient Association. We do have another webinar coming up in a few weeks' time around next of kin, which again is another huge issue on our helpline. But do get in touch with us and let us know. We'll be sending you out some details after this. Chris and Josh, thank you so much, and to Maya and Holly and Olivia in the background helping. Obviously, there is contact details for yourselves on the screen, so they'll come back up again in a minute. But now we'll just quickly go to the step-by-step video that was previously recorded by Chris to tell us how to make a complaint. Thank you very much, everybody.
Hi, I'm Chris, and I'm a solicitor in the Medical Negligence Department at Bolt Burdon Kemp, and I'm going to give you some advice today about the complaints process and how to get the most out of it. Firstly, think about who the best person or the best body to direct the complaint to is. Now, there are a number of options, but there are resources out there to help you make that decision. For example, the Patients Association Making a Complaint leaflet. You may want to make a complaint or write to the healthcare provider in a more informal way at first, perhaps raising it as a letter of concerns. Either way, you have the option to direct a letter to either the healthcare provider themselves, so the GP practice, the hospital, the dentist, or if you're not comfortable doing that, or you feel the relationship's broken down, you can write to the body that oversees or regulates the provider, for example, NHS England or the Care Quality Commission. Secondly, think carefully about the important questions that you would like to ask. This is the best forum to ask these questions, and it's important that you spend the time to do that. If there are more than one party interested in the outcome of the complaint, for example, the wider family, it might be helpful to sit down with everyone and come up with a list of questions together before providing it in one go. If you're thinking about making a medical negligence claim in addition, it may not answer all of the questions that you and the family have, so you will probably be better served directing those questions and asking for those concerns to be addressed at the complaint stage. Now, it's very hard to do this. My third piece of advice would be to try to take the emotion out of the writing. Now, you may well be very entitled to be angry and upset about what's happened, but it's unlikely to help your cause. My advice will be try to stick to the facts, ask the questions, and raise the concerns that you have. Try to remember that you're trying to gain empathy from the reader of the letter, and you're unlikely to do that by directing anger towards them, even if that's completely justified. Fourthly, if you're also thinking about bringing a medical negligence claim, I often get asked this question. People are worried about saying the wrong thing. My advice is always the same. Try not to worry about it, because the complaints process and bringing a civil claim are two very separate things. It would be unusual for anything said in a letter or in a complaints meeting to later undermine a claim. I would try to get the most out of this process that you can. And finally, some general practical tips on how best to set out the letter. I would say that in any piece of writing, the aim is to try and convey the information that you want, or persuade the person. If you're trying to persuade them of something, help them get to that point as quickly and easily as possible. There are a number of ways you can do that. I would say in this context, firstly, set out the date of the incident at the outset and the departments that has happened. Use headings to separate out the sections of the complaint, and bullet points or numbered points to make your points within those. It will be easier for the reader to take on board that information. Try to keep only the most important bits in the letter and ask the most important questions. There will be a huge amount, I'm sure, that you'll want to say in any letter, but try not to let it take away from the most important points you want to make and the important questions that you want to ask. Think, does the reader need to hear this in order to get what I want from them? I would also suggest making your best point first and asking your most important question first. It's tempting to set it out like a story and leave the big conclusion to the end, but my advice will be to put it at the start when the reader is most engaged. Also, take some time before you write the letter and whilst you're writing it to think about the outcomes that you want and state that clearly. That might be an explanation of why something did or didn't happen, an apology, or some reassurance that this is not going to happen again. And finally, I would say, let the letter go cold for a few days and then come back to it. It's amazing what a fresh pair of eyes can do. I do that in my work myself, and I find it's really helpful to spot things that I've missed or parts that I can remove that aren't relevant. So that concludes my advice on the complaints process. I'm sorry that you've got reason to watch this video, but I hope that it's been of some help.